this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in session number 3 of our new series entitled QME Update 2023. And we're continuing along with a series of topics that I'm sure you'll find fascinating in the sense that they all relate to the evaluations that are currently crossing your desk for which you are rendering your most expert opinions as a qualified medical evaluator. And in this series of discussions, I'm sharing with you some ideas that you can immediately use in your very next evaluation. And before we get into the topics of today's discussion, let's just briefly review where we've come from so far in this program so that you can understand the overriding theme and the interconnectedness of the topics that I'm sharing with you throughout this program. In session number 1, we talked about causation, South Coast framing, and you as the qualified medical evaluator. And we'll briefly summarize the overall conclusions of that discussion here in just a moment. In session number 2, we talked about the presumptive injuries under Labor Codes 3212 and 3213. And specifically, we talked about the duty belt presumption and how the duty belt presumption, as well as the South Coast framing case, how both of these sessions were basically just illustrations of the tremendous philosophy operative in California workers' compensation regarding the liberal construction of benefits for the protection of persons injured in the course of their employment. And the duty belt presumption provides tremendous liberal construction to specific classes of employees, specifically police officers in the state of California. Now, in today's session, session number 3, continuing along with our discussion about liberal construction, today's topic is also an extension of that philosophy as it relates to the post-employment cumulative trauma injury claim. Now, to clarify, a post-employment cumulative trauma injury claim is an employee's allegation of a cumulative trauma injury when that allegation of injury is filed after the employee has separated or terminated his or her relationship with the employer. And several laws conspire to provide benefits for this particular species of claim. And it's very, very fascinating. And it's another example of the tremendous liberal construction philosophy that's operative throughout the entirety of the California workers' compensation system. And specifically for this particular class of employees who, for all intents and purposes, file their claims late. These are late filings of claims. And I'll explain how it is that these claims survive and thrive in our system. And these are claims that you're going to be evaluating over and over and over again as a qualified medical evaluator. So today's session is going to be a fascinating discussion for you. In our next 3 sessions after today, we're going to shift a little bit towards more administrative issues. And in session 4, we're going to talk about common report violations. And I'm going to share with you 10 secrets that you can immediately implement into your next report that will dramatically improve the content, quality, and compliance of your report with all of the labor codes and codes of regulation that govern the production of our final finished product, which is our QME report. So that's going to be a valuable session for you. In session number 5, I have a great discussion for you regarding depositions. And I want to put your mind at ease regarding your very next deposition and show you some insider secrets as to how you can approach your participation in your very next deposition so that you can actually relax and enjoy the process and profit greatly from the tremendous potential that depositions bring to the overall portfolio of your QME practice. And then finally, in session number 6, I want to review several of the timelines that are operative in each of our evaluations so that you can be familiar with the timelines, so that you can comply with the timelines, and so that you can use the timelines to your advantage and to your benefit in the day-to-day operation of your QME practice. And I have several insights as to those timelines that I want to share with you. Okay, so with that as the introduction to our overall program, QME Update 2023, let's briefly review sessions number 1 and session number 2, and then we'll get into today's session, session number 3, regarding the post-employment cumulative trauma injury claim. Now, in session number 1 of this program, we talked about causation, AOE, COE, South Coast framing, which is an important and precedential case that discusses causation, AOE, COE, and you as the Qualified Medical Evaluator. And the take-home message from session number 1 was that the principle of liberal construction is operative throughout the entirety of California workers' compensation, and probably nowhere is liberal construction more evident than in the determination, the oftentimes difficult determination of establishing industrial injury, AOE, COE. And we learned from the South Coast framing case that the threshold for industrial injury is very, very low. You know, many times we hear the phrase, the 1% rule, bantered about amongst ourselves and throughout our profession, meaning that the industrial contribution to an employee's symptoms, physical condition, or limitations with activities of daily living only has to qualify as a 1% contribution. This is referred to as the 1% rule. Well, the South Coast framing case even lowered the threshold lower than 1%. In the South Coast framing case, we learned that the industrial contribution necessary for that contribution and that employee's condition or symptoms, or the employee's limitations with activities of daily living, need only be any quantity above 0. Any contribution above 0 qualifies that condition as an industrial injury. And this is very, very important for us when it comes time to prepare our argument in our very next report that deals with the compensability determination under Labor Code 4060, because according to the South Coast framing case, in order to opine against industrial injury, in other words, to provide an opinion that the employee's symptoms, the employee's positive physical examination findings, the employee's condition, the employee's limitations with activities of daily living are not industrial, requires you to argue that 100% of the causes of those symptoms, of those positive physical exam findings, of the employee's condition, of the employee's limitations with activities of daily living are due to non-industrial causes. They must be 100% due to non-industrial causes. And this is a very, very difficult argument to support with substantial medical evidence. And this is something that you need to consider with your very next compensability determination. And that is the low, low threshold and the application of liberal construction to these cases, as was explained to us in the South Coast framing case. So that was our conclusion from session number 1. With regards to session number 2, the presumptive injuries under Labor Code 3212 and 3213, these presumptive injuries are another application of the liberal construction philosophy described in Labor Code 3202. And the presumptive injuries tells us that for certain classes of employees, okay, not all employees in the state of California, it doesn't apply to everyone, but for certain classes of employees, certain health conditions and certain injuries are presumed industrial when certain criteria are met. So this is another application of liberal construction, especially for these certain classes of employees. These presumptive injuries give certain classes of employees the benefit of the doubt for industrial causation for certain conditions when certain criteria are met. And let me just give you an example. Many of the injuries and conditions that are described under the presumptive injuries under Labor Codes 3212 and 3213 deal with pneumonia, deal with heart troubles, and deal with hernia. So I just want to give you an example regarding hernia. I myself had hernia approximately 15 years ago. I was in the gym. I was doing some leg raise exercises for my abdomen, and I felt a little pop and a little pain in my inguinal ring on the right. Okay, so that turned out to be an inguinal hernia. I had to have that surgically repaired, and it recovered, and it was fine. Well, the story is, as relates to the presumptive injuries, if my workout partner, who I was alternating doing this leg raise exercise with, if my workout partner had had a similar experience doing leg raise exercises and felt a hernia himself, him or herself, and my workout partner happened to be a correctional officer, or happened to be a police officer, or happened to be a sheriff, that hernia, even though it happened in the gym on off work hours, even though it occurred on a recreational basis doing exercises for his personal development, that hernia would have been deemed industrial by law, which is Labor Code 3212. That hernia would have been deemed industrial, for which the correction officer, police officer, would go on to receive a permanent impairment rating under Chapter 6 for approximately 19% whole person impairment, and that impairment rating would have been unapportioned according to Labor Code Section 4663, Section E. So same injury, same condition, same clinical course, but because my workout partner was a correctional officer or a police officer, that hernia, by law, is deemed to be an industrial injury for which the employee, the correctional officer or police officer, receives an unapportioned permanent disability award. So it's a tremendous application of liberal construction for these certain classes of injury, because not only is the injury presumed to be industrial, for any resulting permanent impairment, the apportionment of the permanent impairment or apportionment of the disability is waived. It does not apply, and these special classes of employees receive an unapportioned permanent impairment award or permanent disability award. So it's another example of liberal construction, especially as relates to these certain classes of employees. Now, continuing with today's discussion on liberal construction, let's apply the liberal construction philosophy and see how it's operative in the circumstance of the post-employment cumulative trauma injury claim. Now, we're going to lay the foundation for what I have to share with you today regarding the post-employment cumulative trauma injury claim by going over three basic ideas to establish the legal basis for the post-employment filing of a claim for cumulative trauma injury. And then I'm going to share with you what is known, some of the facts that are known about this particular species of claim and case, so that you can properly identify this type of case when it presents to you for your evaluation. And I can tell you that this type of case, this particular species of case, is going to comprise roughly 50% of all the evaluations that you do. And this particular species of case has an exact handling. And I'm going to share with you some ideas as to how you can exactly handle these cases when they come to you. So we're going to begin by talking about what actually is the legal definition of a cumulative trauma injury, and how does that differentiate and how is that distinguished from the opposite end of the spectrum, which is the specific incident of injury. Then we're going to talk about Labor Code 3600, also known as the conditions of compensation liability. And I'm going to share with you the passage in Labor Code section 3600 that allows this particular species of claim to survive, which would otherwise be defeated. This particular species of claim would be defeated were it not for one specific passage in Labor Code Section 3600. And I'll share that with you, and I'll explain that for you, and I'll show you how that loophole allows thousands and thousands of these claims to come to us as qualified medical evaluators. And then finally, to fully understand the concept of the post-employment cumulative trauma injury claim, you need to understand how the date of injury that's assigned to these claims is the force that allows these claims to survive. So very, very important concept, which is described in Labor Code Section 5412, and I'll share that with you. And then finally, once we have established how it is that these claims can survive and how it is that these claims come to be established in the first place, I want to share with you some basic facts that apply to us as the medical evaluators regarding these particular claims that you are going to see operative in your evaluations over and over again. Okay, so let's begin with our definition of cumulative trauma injury. Okay, now cumulative trauma injury is described in Labor Code Section 3208, and this section of the law tells us that a cumulative injury results from repetitive physically or mentally traumatic activities extending over a period of time. This is the cumulative trauma period. So this upper portion of the definition, this refers to the mechanism of injury. The mechanism of injury in these cases is due to repetitive physically or mentally traumatic activities that extend over a period of time. And typically we see these claims for cumulative trauma injuries to extend over a 1-year period, over a 2-year period, over a 10-year period. I've had cases where the cumulative trauma period has been described as the employee's entire career. I recently evaluated a registered nurse who was claiming a cumulative trauma period extending from 2002 to the date of this recording, 2023, a period of 21 years. So that certainly qualifies as extending over a period of time. And you can use this definition in your reporting when describing the mechanism of injury. You can simply state in your report that the examinee's or employee's symptoms are contributed to by repetitive physically traumatic activities in the case of a physical injury, or repetitive mentally traumatic activities in the case of a psych injury, extending over a period of time. And then the question becomes, well, what activities? And there you can go in to describe those activities that contribute to the employee's cumulative injury. So we have the mechanism of injury established, and once the mechanism of injury is established, if that mechanism of injury combines to cause any disability and or the need for medical treatment, then that injury qualifies as an industrial cumulative trauma injury. So it's very, very fascinating. In this sense and in this context, injury is defined as any medical condition that causes disability and or the need for medical treatment, and that is right out of Labor Code Section 3208. So what is disability? Disability. When it says the injury causes disability and or the need for medical treatment, well, typically we think of disability as compensable time off of work. Compensable time off of work. Roughly translated, that sounds a lot like total temporary disability. Well, disability could also be a lesser form of compensable time off work in the form of temporary partial disability, such as an employee who has reduced hours or who has reduced work capacity in the form of work restrictions. So those impacts of the condition on the work ability of the employee qualify as disability. Well, in the case of the post-employment cumulative trauma injury claim, we're seeing employees who are no longer with the employer. We're typically seeing employees who, when they were with the employer, had no periods of work restrictions, had no periods of reduced working hours, had no periods of temporary partial disability, and had no periods of total temporary disability. And so, by definition, they had no work disability as a result of their alleged condition. So, in those cases, particularly in the case of the post-employment cumulative trauma injury claim, the disability is established by the need for medical treatment. And typically, these employees find themselves at a medical provider's office long after separation from the employer with a medical condition, and it's the medical condition that creates the need for medical treatment that brings the employee to either their personal physician or an industrial physician or what have you. But it's this need for medical treatment that then establishes the industrial injury, that then qualifies as the disability requirement necessary to establish injury under Labor Code Section 3208. So we now know about what qualifies as an injury. Let's now talk about the date of the injury, and it's the date of the injury that's going to be critical for the survival of this claim moving forward. Now, the date of injury is going to become very, very important as we discuss how it is that these claims survive and come to us as qualified medical evaluators. And in order to understand the importance of the date of injury, it's necessary to understand a particular section of the law under Labor Code 3600, also known as the conditions of compensation liability. Now, if you've ever had a chance or taken the time to review Labor Code 3600, Labor Code Section 3600, Sections 1 through 9, tell us all of the conditions under which an employee's injury qualify as an industrial injury under California workers' compensation. And you should read these sections and become familiar with these sections, although these sections are not the subject of today's discussion. Today's discussion focuses on the sections after Sections 1 through 9 that talk about the situations that do not qualify as an industrial injury. And these begin in Section 10. Section 10. And you may have heard of Section 10, or you may have seen the reference to the so-called post-termination defense, which talks about how these claims, whether it be a specific injury claim or a cumulative trauma injury claim, how these claims are handled when these claims are filed after the separation of the employee from the employer. So let's read from these sections of Labor Code Section 3600 to understand how this section of the law is operative in our evaluations that involve post-employment claims for cumulative trauma injury. So Section 10 tells us that except for psychiatric injuries, okay, so everything but psychiatric injuries are governed by this section of the law. It says, where the claim for compensation is filed after notice of termination or layoff. Okay, so the employee gets a notice on, say, December 1st. They get notice that on January 1st, the plant is closing and you will no longer have a job. Or they get a notice that they're being fired. Or they get a notice that they are being laid off. Or they get a notice that there's a temporary shutdown of the shop due to the COVID-19 pandemic or whatever. When the claim is filed, claim for compensation is filed after notice of termination or layoff, including a voluntary layoff, and the claim is for an injury occurring prior to the notice of termination or layoff. Okay, so employee gets a notice of termination or layoff on December 1st, and then comes to the employer and says, you know what? On November 1st, I suffered an injury. The claim is for injury prior to the notice of termination or layoff. The law, Section 10, tells us no compensation shall be paid. no compensation shall be paid. This is the law. When an employee files a claim for injury after receiving notice of termination or layoff, and the claim is for injury occurring prior to the notice of termination or layoff, no compensation shall be paid. It's the law. Unless, and this tells us here that there's a couple of exceptions to this particular section of the law. It says, unless the employee demonstrates by a preponderance of the evidence, okay, so here the law tells us who the burden of proof falls upon. The burden of proof falls upon the employee, that one or more of the following conditions exist, and these are known as the exceptions to the post-termination defense. And here we're going to see how it is that we come to see thousands and thousands of these post-employment claims. So let's dive into the most important and most relevant for us of these exceptions. Now, the first of these exceptions under Labor Code Section 3600 are going to make sense to you and are very, very clear. The first one, exception under 3610A, tells us that there's an exception that compensation can be paid and the injury can qualify as an industrial injury when the employer has notice of the injury prior to the notice of termination or layoff. And that makes sense that if an employee receives a notice of termination or layoff today and tomorrow files a claim for industrial injury, if the employer already has notice of that injury, then that injury can proceed forward and can qualify as an industrial injury. So that's exception number one. Exception number two is when the employee's medical records existing prior to the notice of termination or layoff contain evidence of the injury. And I've had these types of cases before where a company is closing, the employee receives notice of termination or layoff or notice that the plant is closing, and then the employee files a claim for industrial injury. That claim initially becomes denied by the claims administrator, but the claim can become an accepted claim when the employee can demonstrate that the medical records, all in the time period preceding the notice of termination or layoff, contain evidence that the employee was receiving medical treatment, was receiving diagnostic workup for the injury even prior to the notice of termination or layoff. So those two make very good sense, and these two exceptions are in the law to provide protection to persons who were actually injured on the job, but for whatever reason did not file the claim for injury, and we're going to hear hundreds of reasons as to why, but did not file the claim prior to notice of termination or layoff, but who actually were injured in the course of and arising out of their employment. So these exceptions protect those particular injured workers. Now, these next two exceptions under Labor Code Section 3610 are not as intuitive as the first two, but as you're going to see, they make perfect sense in that they protect persons actually injured in the course of their employment, even in those circumstances when the claim for injury is not filed until after separation of the employee from the employer. So under Section C, this has to deal with the date of injury now for specific injury claims. It tells us that the date of injury for a specific incident of injury, and that's what's described in Labor Code Section 5411, talks here about specific incidences of injury. So the date of injury is subsequent. Subsequent means after. Is after the date of the notice of the termination or layoff, but prior to the effective date of the termination or layoff. So this exception applies to specific injuries that occurred before the effective date of termination or layoff. So to illustrate this, with an actual case. Imagine an employee who receives a notice of termination or layoff on 10/1/21. 10/1/21. With an injury 1 month later when the effective date of the layoff is 1 month after that. So stated differently, on 10/1/21, the employee receives notice that you're going to be laid off, the plant is closing, whatever. And then the effective date of the layoff is 2 months later on 12/1/21. So the employer gives the employee 60 days notice that the plant is closing. Well, is it possible that some employees could actually suffer bona fide incident of specific injury claims somewhere within this 60 days time frame between the notice of termination or layoff and the effective date of termination or layoff? Of course it could. Of course it's possible to have an actual injury in this time frame here. So when the injury is prior to the effective date of the termination or layoff, this injury qualifies as an industrial injury, and compensation in this case shall be paid. And this relates to specific incidences of injury. So that exception relates to the date of injury with regards to specific incidences of injury. With regards to cumulative trauma injuries, and this is what's important for us to understand, that the exception that allows cumulative trauma injury claims to be filed post-employment occurs or becomes operative. The exception becomes operative when the date of injury is subsequent, meaning after the date of the notice or of termination or layoff. And this date of injury can be any date after the date of notice of termination or layoff, and there is no statute of limitation. That date can be 1 day, 10 days, 10 weeks, 10 months, even 10 years after the date of the notice of termination or layoff. So to illustrate this particular scenario, and this is what we're going to see in our evaluations over and over again, imagine an examinee who has, on October 1st, 2021, receives notice of termination or layoff. And then again, as in our prior scenario, the effective date of termination or layoff is on December 1st, 2021, again, 60 days notice of termination or layoff. And then the date of injury is sometime after the notice of termination or layoff, and in many cases can be long after the actual effective date of the notice of termination or layoff. And here in this example, I use a date of approximately 7 months later, but it could just as easily be 7 years later. Now you might ask yourself, if an employee is separated from the employer and is no longer engaging in repetitive physically traumatic activities at the workplace, how can a date of injury arise after separation from the employer? Well, that's where the definition of the date of injury under Labor Code Section 5412 becomes operative. So let's review this particular section dealing with the date of injury for a cumulative trauma injury claim. Now, this date of injury for cumulative trauma injury claims is very, very fascinating, and it's important for you to understand that the determination of the date of injury in a post-employment cumulative trauma injury claim is not a medical determination. We as qualified medical evaluators do not assign this particular date to the date of injury. The date of injury is an administrative decision, a non-medical decision, but it's important for us as medical evaluators to understand the legalities operative behind the scenes that then bring these cases to us in the hundreds and thousands. In fact, according to a statistic by the RAND Corporation, there's approximately 30,000 of these types of cases being filed each month here in the state of California. So These claims are very, very prevalent, and it's important for us to understand the date of injury and how that relates to the survival of these claims, considering that these claims have to survive the post-termination defense under Labor Code Section 3610. So here in this section of the law, Labor Code 5412, it tells us that the date of injury in cases of occupational disease or cumulative trauma injuries is that date upon which the employee first suffered disability therefrom. And in these cases, disability refers mostly to the need for medical treatment, because at this point, these employees are long separated from the employer and have no history of suffering any work-related disability during the period of employment. So here we're mostly referring to the need for medical treatment. So it's the date upon which the employee first required medical treatment therefrom, and either knew or in the exercise of reasonable diligence should have known that such need for medical treatment was caused by his present or prior employment. And here the law introduces the word prior employment, thus opening up the potential for claims to be filed against former employers after the employment relationship has ended. So it's critical for you to understand in this particular section of the law the concept of knowledge. Knowledge is described here twice in this section of the law. So the date of cumulative trauma injury is the date of intersection of two things. First is the intersection of disability, and then is the date upon which the knowledge intersects with the disability. So a person can have knowledge without disability, a person can have disability without knowledge, but the date upon which those two intersect becomes the date of injury on an administrative basis for these cumulative trauma injury claims. Now, typically the employee gains the knowledge or obtains the knowledge that the disability or need for medical treatment is caused by the prior employment by a medical provider. So this employee could be at their primary care physician, and it's the primary care physician that makes an assessment, renders a diagnosis, and renders the conclusion that, hey, this condition that you're now needing medical treatment for, this condition could be contributed to by your former workplace duties with former employer ABC. So it's the intersection of the disability with the knowledge that establishes the date of injury for these cases. And many times this knowledge and even the disability is not achieved or arrived at until after the employment relationship has been terminated and the employee has been separated from the employer. So this particular nuance in the law that deals with the date of injury, this is what allows these types of claims to survive and to go on and to become bona fide industrial injuries in the state of California. And this is what brings these cases to us in gobs and gobs as qualified medical evaluators, typically requiring a compensability determination from us under Labor Code Section 4060, as most of these claims come to us as denied claims for which we render our expert medical opinions. And this is again where the whole concept of the low threshold of industrial causation comes into play. And this is where, again, the law provides for tremendous liberal construction to protect those persons who actually were injured in the course of their employment, but for 100 different reasons simply failed to report that injury until after the employment relationship was concluded. So now that we know how it is that these cases come to be established in the first place, let's talk about a few facts about what is known about these types of cases, these post-employment cumulative trauma injury cases, here in the state of California so that we can recognize these cases when these cases come to us, and so that we can recognize some of these scenarios when they present to us. So the information that I want to share with you now comes from a very recent study from the Workers' Compensation Institute Review Board, a research organization here in the state of California that compiles all of these statistics regarding workers' compensation. And they've published a very recent study in late 2022 entitled The Post-Employment Cumulative Trauma Injury Claim. And the amount of information that's known about these claims would blow your mind. And it's absolutely amazing, the statistics and the facts that are known. And this particular research paper or research study is a subset of a larger study entitled The World of Cumulative Trauma Injury Claims, also published by the WCIRB, the Workers' Compensation Institute Review Board. And I suggest that you review both of these studies, both of these research papers. And I provide links for both of these studies in the handout materials for today's discussion. So what is known? Well, what is known, and this has to deal with the industry sectors that are filing these particular types of claims. And it's known across which industry sectors the greatest percentage of these cumulative trauma injury claims are filed on a post-employment basis. And it's known that it's the manufacturing industry, as represented here by this red bar graph, that represents the post-employment cumulative trauma injury claim filings. So of all injury claims filed in the manufacturing industry, 49% of all claims are filed for cumulative trauma injuries, and those claims are filed post-employment. Manufacturing industry sector leads all industry sectors in the filing of these particular types of claims. So you may ask yourself the next time you are presented with one of these claims to evaluate, what is the industry sector that my examinee works in? And there's a high likelihood that they're working and are involved in the manufacturing sector. Now, the post-employment claims are to be contrasted with the regular cumulative trauma injury claims that are filed during the employment relationship. And in manufacturing, you'll notice that the percentage of those claims is way, way down compared to the percentage of claims that are filed post-employment. And this is starkly contrasted with those volume of claims that are for specific injury claims, also in the manufacturing sector. So you can see that the post-employment cumulative trauma injury claim greatly, greatly exceeds even the specific injury claim filings in this particular industry sector. And other industry sectors that lead in the filing of post-employment cumulative trauma injury claims include the hospitality sector, the transportation and warehousing sector, the retail sector, and the clerical sector, with diminishing contribution of the post-employment filings of 6%, 5%, 5%, 5%, and diminishing thereafter in other industry sectors as well. So this represents the industry sectors that you're going to be seeing on the greatest frequency involving these post-employment cumulative trauma injury filings. So that research tells us who is filing these claims for post-employment cumulative trauma injuries. It's largely the manufacturing sectors, followed by other industry sectors as well, but those other industry sectors are a far distant second to the manufacturing sector. Well, what else is known about the filings of these claims? Well, we also know where these claims are being filed in the state of California, as depicted on this graph here. It's known that the bulk, the great bulk of the claims for cumulative trauma injury filed post-employment come out of the Los Angeles Basin area. And I'm going to show you a map in just a few moments. in our next slide to show you where these claims are concentrated in the state of California. Well, where they're concentrated, as depicted by this particular statistic, is in the Los Angeles Basin area. And secondarily, as we're going to see, they're also concentrated in the San Diego area as well. So in the Los Angeles Basin, the post-employment cumulative trauma injury claims, of all claims, over approximately 90% of all claims filed post-employment for cumulative trauma injury are filed in the Los Angeles Basin area, whereas the rest of California only has a teensy tiny percentage of these particular types of claims. This is a very fascinating statistic. So if you're a qualified medical evaluator in the Los Angeles Basin area, you're going to be seeing, let's just say, lots and lots and lots of these particular types of cases, because these particular types of cases are abundant down in your area in the Los Angeles Basin area. So let's show a map that depicts the specific distribution of these types of claims throughout the entirety of the state of California. Now, here's a map, and this is again from a study published by the WCIRB here. This is a map of the state of California that shows the percent of total claims that are cumulative trauma claims by region within the state of California. And here you can see that the red depicts the highest concentration of cumulative trauma injury claims. And the red is found down here in the Los Angeles and Long Beach area here. Now, in diminishing frequency, as we move outward from Long Beach and Los Angeles, we have area number 13, which is Santa Monica and San Fernando Valley. And then 17 here, which is Orange County. These are the highest frequency areas within the state for the filing of cumulative trauma injury claims. So if you're a qualified medical evaluator in these parts of the state, you're going to be seeing a high percentage of these cases. Now, up here where I live, up in area number 1, up here in the outskirts of the Sacramento region, you can see very, very few filings for cumulative trauma injury claims. So we up in these areas don't see as many of these types of cases. But down in the Southern California areas, you need to be very, very familiar and very, very competent at recognizing these types of cases, because you're down in these parts of the state where these particular types of claims are being filed on a very, very frequent basis. So we know who are filing these claims, and we know where in the state of California these types of claims are being filed with greatest frequency. What do we know about the types of conditions that these particular examinees come to the Qualified Medical Evaluation with? Well, again, from the Workers' Compensation Institute Review Board, we know that the most common medical diagnoses include soft tissue disorders, primarily soft tissue disorders. These are the neuromusculoskeletal conditions that we get as non-psych evaluators, non-psych qualified medical evaluators. Also are the dislocation and sprain diagnoses, the mental and behavioral disorders for the psych evaluators. Many claims involve multiple injuries and multiple body parts, including soft tissue disorders and the dislocation and sprain diagnoses. And then, of course, numero uno, number 1 named type of diagnosis is the carpal tunnel syndrome, upper extremity diagnosis. So these are the types of conditions that we're going to see as qualified medical evaluators. So if we put these three factors together, we know that on a cumulative trauma basis, and particularly for those claims filed post-employment, the typical case involves an employee separated from the manufacturing sector, an employee from the Los Angeles or San Diego County areas, particularly in and around Long Beach and Orange County areas. And this particular employee is going to present to the qualified medical evaluation with carpal tunnel syndrome or other types of soft tissue disorders that you as a qualified medical evaluator are very, very familiar with. So this gives you some idea as to the profile of the examinee that you're going to be dealing with in these particular claims that typically involve denied claims for which the examinee comes to you for a compensability determination in an effort to defeat the post-termination defense under Labor Code Section 3600, Section 10. So doctors, I hope this helps you. You know, the purpose of the exceptions under Labor Code Section 3600 is to protect persons injured in the courses of their employment who, for whatever reason, did not develop disability and did not have the knowledge that that disability was caused by their present or prior employment until after the employment relationship has ended. So there are many, many scenarios where this represents an actual situation. Imagine the occupational diseases where an employee works in an asbestos environment for their entire career and then has a happy and healthy retirement, or so it seems, but then a year, 2 years, even 5 years later develops a cough or some other type of respiratory condition. Well, this condition is actually an industrial injury and actually arose out of the employment, but the employee did not suffer disability, did not need medical treatment, and had no knowledge that this condition was related to the employment until after the conclusion of the employment. And this is a perfectly legitimate scenario, and this section of the law protects these persons. And this is just another example of the liberal construction policy or philosophy in the state of California that provides benefits to persons injured in the course of their employment. So it's very, very important for you to be able to understand the post-employment cumulative trauma injury claim, and also to be able to recognize this type of claim when it presents to you for your evaluation, because you're going to be seeing a lot of these, especially in the southern portions of the state. So I want to thank you for taking the time to join me on today's discussion. I want to thank you for your commitment to excellence in the work that we do. I want to thank you for your dedication to quickly and accurately resolving disputed issues in the California workers' compensation system. And I want to thank you for taking the extra time, the extra energy, the extra effort, for going the extra mile in the service of California's injured workers. For now, this is Dr. Perry Carpenter wishing you best of success in your career as a qualified medical evaluator.